Okay, I think that we shall begin. Good evening, everyone. I'm Sheila Boston, the 69th president of the New York City Bar Association, and I welcome you all to this vitally important program entitled Another Crisis at the U.S. Border, Haiti, Title 42, and Our Obligations under International Law. I wish to thank the City Bar's Immigration and Nationality Law Committee and its chair, Danny Alicia, for pulling this program together on such short notice. Thanks to our International Human Rights Committee, chaired by Ramya Kudakalu, for co-sponsoring this program, and of course, our distinguished panelists for participating, as well as to all of you, those who are giving of your time to watch the program and learn. So, here we are. Yet another crisis at the border, marked by inhumane treatment of migrants fleeing inhumane conditions. Those of us who expected something different under a new administration, quite frankly, find it doubly troubling. And I think it's safe to assume that among the last things the Biden-Harris administration would want the whole wide world to see is the indelible image of a roundup on horseback of human beings, with its attendant awful historical resonances. So, what does it tell us that events like this are taking place? What does it tell us that this is considered acceptable behavior by those who act as our agents in our name? Could it be that it's an entrenched problem with no quick and easy solution? Could it be that it's part and parcel of the law enforcement culture issues that have been front and center these past few years? That when encountering certain kinds of people, does the impulse to herd them on horseback come from the same place as the impulse to shoot them first and ask questions later, or even to kneel on their necks for minutes on end? Coming from a law enforcement family, my husband's a retired New York State trooper, my son a corrections officer, you could say that I am triply troubled on a personal level. And on a professional level, I can't help but see this situation as another instance of my City Bar agenda items converging. I have 6 pillars for my presidency, and I see 4 of them at play here: criminal justice reform, diversity, equity, and inclusion, access to justice, and the rule of law. Now, in the long run, progress may be required on all these fronts to achieve the kind of change for which we all yearn, which is not to say we can't make a difference in the short term. We can provide a forum and explore the questions posed in the description of this program, such as, is what's happening at the border legal under US and international law? And what is going on with Title 42? Can we manage our border and respect human rights at the same time? What can we all do to provide legal and other resources to Haitian and other refugees? Well, these are the questions we ask and the things we do as an association. And I think you all know I affectionately call this association the Bar of Hope. Now, as I noted in my recent statement on this situation, the City Bar has long spoken out on immigration issues, regardless of which political party is in the position of leadership. And the City Bar has backed up its words with action. As a matter of fact, the City Bar's organized pro bono legal services work was built on immigration issues in the 1980s. And as it happened, it was on behalf of Haitians when our Immigration and Nationality Law Committee trained and mobilized pro bono lawyers to assist on Haitian asylum claims. Now, when the 1986 amnesty law provided a 1-year window during which up to 8,000 undocumented immigrants in New York City could apply to legalize their status, it's the City Bar that hosted clinics where undocumented immigrants could meet with volunteer lawyers to sort out what was a rather confusing process. And thus was born the Community Outreach Law Program, which would become the City Bar Justice Center. In 2010, after the US announced the availability of temporary protected status to undocumented Haitian nationals following the devastating earthquake in Haiti, volunteer lawyers, interpreters, and notaries lined up and down the block for a clinic co-sponsored by the City Bar and the American Immigration Lawyers Association to help Haitian New Yorkers. And it was the largest turnout of volunteers we could recall since 9/11. While I am indeed delighted and profoundly grateful that the City Bar is convening this program with representatives of the ACLU and the Refugee Solidarity Network, along with a private practitioner, to sort out the legal issues of concern at the border and determine what can be done to improve the situation. Y'all, I believe we are at a moment when it is crucial for like-minded groups to join together to counter the forces that can at times seem insurmountable. But I sincerely believe, again, we are the bar of hope. And I believe there is no limit to what we all can do together. I'm proud to introduce this program, to welcome you, and for it to take its place in the long history of the City Bar's work in upholding the rule of law and access to justice, in holding our leaders accountable, and in helping our newest immigrants or would-be immigrants, whoever they are and from wherever they come. Let's have an instructive, inspiring, but real talk conversation. Thank you all.
Thank you so much, President Sheila Boston, for those welcoming remarks. And thank you for authoring that statement that you mentioned on this subject. So my name is Danny Alicea, and I am a supervising immigration attorney at the Center for Family Representation. Today, I come to you in my capacity as chair of the Immigration and Nationality Law Committee. And I want to thank Ramya, chair of the International Human Rights Committee, for putting this panel together with me. In addition to thanking Sheila, I want to thank all of our panelists, whom I will introduce to you shortly. As an extension of President Sheila Boston's statement on the issues at hand, we wanted to convene this group of experts to provide further thoughts, reactions, and analysis on what recently transpired when several Haitian families fled their home countries and made the treacherous trek up America and to the US border. We will start with an immigration attorney's perspective. Miriam Lacroix, herself a Haitian American and immigration committee member, will give us more insight into who these families are, what they fled, and what the protocols are that are in place when anyone arrives at the US border. After Miriam, we are honored to hear from John Blazer. As the ACLU's first director of border strategies, John drives ACLU's efforts to build strong and sustained support for humane border policies, working in close collaboration with the ACLU's Southern Border affiliates. And rounding out our panel of experts today is Zaid Hidari, the executive director and co-founder of the Refugee Solidarity Network, a US-based nonprofit that works to protect the rights of people uprooted from their homes and strengthen the communities where they seek safety. Zaid will give us an international law perspective on the US's obligations with respect to displaced persons. As we move now into the substantive portion of today's event, think on a macro level about intersectionality and how structural forces such as vulnerability and systemic racism may be at play. Now add to that a global pandemic. The issue of structural racism is particularly relevant to the en masse denials of protection, dignity, and asylum, and especially the deportation of Haitians and other vulnerable immigrants. Keep in mind that TPS was recently, or Haiti was recently designated for TPS specifically because of our concerns about public health, political turmoil, and natural disasters. That said, I'd like to turn it over to our first speaker today, Miriam Lacroix. And Miriam, could you give us your perspective and expertise about the border problem?
Absolutely, thank you, Danny. What we saw at the border against Haitian migrants seeking protection is not new, but the most recent illustration of a long history of injustices and human rights violations happening at the border. Like not too long ago, we were horrified at the intentional separation of children from their parents. as a cruel way to deter migrants. And of course, we're still addressing the effects of that today. But specifically for Haitians, there has also been a long history of disproportionate treatment of Haitians, especially when it comes to seeking entry into the US. Haitians are granted asylum at the lowest rate of any nationality, with consistently high numbers of asylum seekers. During COVID last year, between March and June, Haitians represented the highest number of people being detained. And not only are they more likely to be detained, but Haitian immigrants pay much higher bonds than other immigrants in detention. Between 2018 and 2020, Raices did a study on who they were giving bond money to, and they noticed that bond for Haitians in immigration detentions averaged about 54% higher than for other immigrants. And so the treatment of Haitians, together with the already restrictive border policies, has led to the images that we saw. And keep in mind, Haitians seeking protection at the border has significantly increased in the recent months, but it's something that's been building up for a few years, right? After the earthquake in 2010, many Haitians immigrated to South America, mostly Brazil and Chile. But recent restrictive immigration laws in those countries have led them to the US now. And political turmoil, the assassination of the Haitian president, natural disasters, all prevent them from returning to Haiti safely, and it leads them here. So when we talk about the border problem, or we hear things like the crisis at the border, I think less about how many people are attempting to cross at any given time, and more about how our government chooses to treat them when they do. And this just speaks to the necessity of a more comprehensive, humane system at the border.
Wow, thank you for that. Okay, so speaking of the system that, such as it exists at the border, could you, Miriam, give us a little bit more information about what protocols are already in place that exist, or either theoretically or actually in place at the border?
Yeah, sure. The US immigration law basically says that a person who is either physically present in the United States or who arrives at the border, whether or not at a port of entry, has to be given the opportunity to seek humanitarian protection, such as asylum. And asylum is a type of protection for those who may be persecuted in their own country because of a protected ground like race or religion, nationality, or political opinion, or membership in a particular social group. So what used to happen is that migrants would be placed in a process called expedited removal. And so border officials are supposed to ask about this person, the migrant's fear of returning. And if they decide based on that questioning that this person isn't eligible for humanitarian protections, they can be removed without having to go before a judge. But if they do express fear, then they're supposed to be placed in detention and given what's called a credible fear screening by an asylum officer. And credible fear is a very low bar. They basically just have to show that there's a significant possibility or a 1 in 10 chance that they'll be persecuted in their home country because of that protected ground. So if they get a positive credible fear finding, they could be released until they have the opportunity to apply for asylum in front of an immigration judge. But if they don't pass the screening, if they get a negative credible fear finding, then they're removed or they remain detained for a review by an immigration judge. But once an immigration judge gives a negative finding, then that is final and they could be removed. By the way, this process doesn't apply to children. So that's pretty much the process at the border, theoretically how it was at one point. But now, one thing that's important to mention is that the executive branch does have some discretion related to this process. For example, instead of detaining people migrants could be released with ankle monitors, and wherever they're going within the United States, they'd have to check in at an ICE office. But oftentimes, executive discretion is used in a negative way. In recent years, the ability to seek asylum has been severely restricted, especially under the Trump administration. And some examples of this would be metering, or what they call queue management, which is where Customs and Border Patrol would limit the number of individuals who are permitted to access the asylum process each day at a port of entry across the border. There was also the migrant protection protocols, which we know to be called also Remain in Mexico policy, which outlined procedures under which the US government would return certain asylum seekers to Mexico to wait there for their immigration hearings, for their asylum hearings. There was the transit ban. So basically with the transit ban, it banned asylum for individuals who entered the United States at the southern border after transiting through a third country, after leaving their home. So all of these things were either reversed by the Biden administration or blocked by federal court. But one thing that started under the Trump administration was the use of Title 42, which John will talk about in more depth, but it basically prevents entry of migrants due to public health concerns. So this is how this administration was able to rationalize its expulsion of Haitians recently, by using Title 42. Just to mention one other thing that this administration is attempting to do to change the border process, is with a proposed rule that would actually change the expedited removal process that I just mentioned, and dramatically speed up the asylum process by having asylum officers decide cases instead of judges. There are, of course, grounds for concern with this proposed rule, especially in regard to access to counsel and how it would be implemented.
Thank you so much for all of that information, Miriam. For the people who are tuning into today's event and who may be curious about what efforts are taking place to help actual Haitian people and Haitian families, is there any advice or any tips that you can provide for what people can do to help, what resources are needed, be they legal help or otherwise?
Yeah, absolutely. I think can you hear me just fine still? I was frozen a little bit, okay. Yeah, so there have been organizations on the ground for many years shedding light on the invisibility of Black immigrants in immigration media in general, and the disproportionate effects border policies and immigration policies in general have on Black immigrants, because they have this unique experience as they sit at the intersection of race and immigration status. So one organization would be the Haitian Bridge Alliance. There's also UndocuBlack and the Black Alliance for Just Immigration, also known as BAJI. And these organizations on their websites have amazing reports and have done studies on topics like these. And then one of my colleagues has also been in contact with the Val Verde Border Humanitarian Coalition, who's been doing some on the ground donations, drives, transportation for people who are reuniting with their family now, Haitians reuniting with their family. And they're of course looking for attorney referrals for those who they come across going into different states. So ways to help these organizations, of course, would be to donate so that they continue their work in shedding light on, what's happening not only at the border, but in the immigration world in general, especially how it affects Black immigrants. Also, volunteering your time. I know there were buses of Haitians who were released going to places like Florida, Boston, Massachusetts, New York, and Pennsylvania. And those are the main states that I've heard of that are going to need legal representation. And a friend of mine is actually putting together a panel of attorneys who would be willing to volunteer their time. But the last thing that I'll say that people can do to help, it's always helpful if you can't volunteer time or money, is to share on your platforms about what's going on and to bring light to the immigration human rights violations, and as well as the racial justice issues at the border. Because those seeking protections at the border are overwhelmingly Central American, they're indigenous, they're Black. And so restrictive policies like these have a disproportionate impact on these groups. And I think, shedding light on that is really important at this time.
Absolutely. And thank you so much, Miriam. Thank you for speaking today, for your remarks on behalf of yourself and the work that you're doing for the Haitian community and on behalf of the immigration community as a member. I am certain that both John and Zaid might have reactions to some of the things that you said or things to add. So why don't we turn now to our next speaker, John. John, thank you for being here with us on behalf of the ACLU. We really appreciate your time and expertise. I know that people want more information about exactly what is meant when we talk about invoking Title 42 and public health grounds to keep people out as a public health concern. So I think we'd like to hear more about that from you, but I think I could just frame the question as Miriam talked to us about the protocols that should be in place. It doesn't appear, they do not appear to be in place such as they are written, or maybe they are, but they are not working. So can you just give us your perspective on what exactly is happening?
Yeah, thanks, Danny. Thanks, Miriam. I'd like to talk about a couple things. Let's start with the Title 42 order, and if time permits, I think we also witnessed vividly and horrifyingly violations of public trust in the Border Patrol through the abuse that many of us saw in Del Rio, Texas. The Title 42 order derives from a public health law from the 1800s, which does provide the government the authority to take certain extraordinary measures to protect the public health. However, it has never, ever been interpreted to authorize deportations of individuals inside the United States, let alone summary, quick expulsions of individuals without processing their asylum claims. Notably, the law arose before we had an asylum system in place in the United States, before we had a Refugee Protection Act, before we signed the Convention Against Torture that provide fundamental humanitarian protections. And this law the order under Title 42 first came out under the Trump administration in March of 2020, right at the beginning of the COVID crisis. It was ordered against the objection of career officials within the Center for Disease Control, which did not believe it would be effective as a public health measure. But Stephen Miller was really hot on doing it. And he had been trying for some time. This is the xenophobic advisor to President Trump, who also was the mastermind behind a number of the other orders that Miriam walked through under the Trump administration. He saw it as the pandemic as a big opportunity to finally close the border to asylum seekers. And it started as the 30-day order, and since then has been extended. And what it says is that the federal government has the authority to automatically expel any covered aliens who attempt to enter the United States, and they have interpreted that to mean anyone who is picked up within the country at the border between ports of entry. And they've also interpreted, importantly, to justify shutting down asylum claims at ports of entry where people normally present for asylum. And the ACLU, I should also just say in terms of the harms, under the Biden administration alone, in several months of this year, over 100,000 individuals have been summarily expelled under Title 42. I think the total number since that order was in effect is approximately 1 million people now since March of 2020. And we are in direct contact, unfortunately, heartbreakingly, with families and individuals who have been kidnapped, raped, and assaulted after being returned to harm in Mexico and in their home countries. And we've been representing different classes of individuals since last year, challenging the unlawfulness of the Title 42 order. Last year, the ACLU and its partners, co-counsel in litigation, secured an injunction prohibiting the government from applying Title 42 to unaccompanied children at the border. Unaccompanied children have some additional protections guaranteed to them. Interestingly, the Supreme Court stayed that injunction, and to its credit, the Biden administration chose not to resume Title 42 against unaccompanied children. They could have under the Supreme Court stay. They chose not to. But we then moved with partners to challenge Title 42 as applied to families with children. Last month, we won a ruling from the DC District Court holding that we were likely to succeed on the merits of our litigation, and therefore issuing a preliminary injunction ordering the Biden administration to stop applying Title 42 to families. Unfortunately, the government made the decision to appeal that ruling to the DC Circuit Court of Appeals, which issued a stay last Thursday. And it's a devastating outcome for us, because I think the implications are that now we're probably going to have to wait until fuller argument on the merits in front of the appeals court in December or January to get any change in the status quo through the litigation. I think, though, that simply highlights the importance of our public advocacy on the issue. We need a political solution to this. It's really never been about the law. We know from people inside the administration that they view this as an immigration control measure and not a public health measure, and they're afraid to let go of it as a convenient tool to be able to control the borders and not follow humanitarian protection laws. And we have to kind of speak out on it. I think the situation in Del Rio, Texas, and the gross mistreatment of migrants in Del Rio, Texas, put an additional spotlight on how that law serves as a tool for cruelty. For the first time, we heard New York Senator Chuck Schumer speak out forcefully against Title 42, and we heard other voices that we haven't yet heard as part of that debate, other members of Congress. And I want to think that we're also starting to see some of the first cracks in high levels of the administration over this policy. Over the weekend, Anthony Fauci was asked a question, and in his clever way, sidestepped it a little bit, but he knew what he was doing. He said that, I don't know the intricacies of that particular policy, but it's never been my belief that we are going to get out of this pandemic by expelling immigrants out of the country. And let's be honest, and let's look at the reality here in terms of how this pandemic is spreading. And I think people may have seen also that on Monday, it was revealed that the State Department's most prominent legal advisor, Howard Kuo, many of us also know as a long-term champion of asylee rights and refugee rights, former dean of Yale Law School, resigned in protest. And he has issued a scathing memo upon his departure about the unlawfulness of Title 42 and how it could no longer be associated with its continued application against anyone, let alone Haitians. So I'll stop there for a moment before talking a little bit, if there's still time, about what we witnessed with the Border Patrol's direct treatment of Haitian migrants. Danny, to see if you have any other questions.
That's great, John. Thank you for that. Actually, we can move into what you premised as the public trust impact based off of and reactions to CBP's behavior at the border and what your remarks about that.
Okay, thanks. Yeah, I mean, so many of us witnessed Border Patrol agents domineering, white appearing Border Patrol agents, I will say, domineering over Black migrants, menacing and charging into them with horses and their reins raised in whip-like fashions, making we heard derogatory comments, insulting people. So the eyes of the country was on the Border Patrol for a couple of critical weeks in Del Rio. But the truth is that agents of Border Patrol have been acting this way for many years out of the public view with impunity. And like, we've got to make this a moment for there to be a reckoning and overhaul of Customs and Border Protection, the larger agency that houses the Border Patrol. This is an agency that was first established as a very small agency during another anti-immigrant moment in history in 1924. At its inception, it employed white supremacists, including Ku Klux Klan members, and the early days of the Border Patrol were a horror show of beatings, shootings, hangings of migrants at the border. So we're seeing something now that, for people who have followed that agency from the beginning, have seen all along, in a way. Even though it started small, it has been on a huge growth spurt since the early 2000s. The Border Patrol's ranks now include nearly 20,000 agents, and that makes it the nation's largest law enforcement, and I think rightly considered, policing agency. And even though it's the largest agency, it's also the least accountable. They have none of the basic ingredients of a complaint process where there's any transparency about how complaints are handled, resolved. Their disciplinary process is a black hole. What we do know is that 191 people at least have died in the last decade following encounters with Border Patrol. 6 of these deaths were caused by Border Patrol agents shooting across the border into Mexico. And no agent has ever been accountable for those killings. The agency lacks basic accountability practices. None have been ever convicted of criminal wrongdoing while on duty. And the rules are kind of set up to protect Border Patrol agents that way. And while we and many other partners, I think, rightly immediately called for the dismantling of that horse patrol unit that was so noxiously deployed in Del Rio, that's really just the tip of the iceberg. That agency has to fundamentally reform its use of force standards, its trainings, its hiring and screening process, its public disciplinary guidelines. And we have to have a publicly accessible national database of complaints and written resolutions. And just as Sheila Boston noted that we expect more of the Biden administration with respect to their handling of asylum seekers at the border, we expect them to deliver on their promises to bring reforms to the Border Patrol and to make sure that agents that commit abuse are held accountable and that they incorporate the best practices from other law enforcement agencies into the nation's largest police force.
Thank you, John. I think that those calls for action are quite important. I'd like to write them down because in terms of a call for action on accountability for CBP as an agency and their accountability, I think you pointed out exactly what needs to happen. And so I hope people are listening and that viewers, the public, and perhaps other agencies and committees will take into account exactly what you listed and what Sheila Boston mentioned earlier, and take on those initiatives as well. So I think if you're okay with this, John, I will move to our next speaker, who Zaid, you have now heard from Miriam and John about US law, both about federal law, federal proclamations, as well as border laws and procedures. Can you talk to us from an international law perspective about, or give us your perspective about the things that John and Miriam so eloquently described to us? And let us know, the tail end of the title for this panel references our obligations under international law with reference to displaced persons. Are we meeting those obligations? And what else can you say on this subject?
Yeah, thanks, Danny. I'm indeed going to focus my comments on that question of whether our policies, more specifically Title 42, have been in line with international law and international legal obligations. I guess the spoiler is that I, and like many others, believe that they don't conform with our international obligations. I'm going to maybe just map out what those obligations are first and foremost, and where do they come from. So this obligation that we're concerned with, I'll refer to as the non-refoulement obligation, which is essentially what we've been discussing throughout the panel. Miriam mentioned it, Jonathan mentioned it, the obligation not to return an individual to harm. That's enshrined in Article 33 of the 1951 Refugee Convention. It's clear that that is the absolute bare minimum obligation that signatory states have to not refoul or return or expel someone. It's used in any manner whatsoever to the frontiers of territories where their life or freedom would be threatened. The US is a signatory to the 1967 protocol relating to the status of refugees, which thereby makes us bound to the 1951 Refugee Convention. So the question really in my mind is, are there any exceptions to this obligation under international law? Does Title 42, ostensibly a public health measure, create a justifiable exception to this legal obligation not to return individuals? And I'm going to quickly look at the explicit exceptions under the 51 Convention, and then talk about some less explicit interpretations under customary international law. So first, there are a couple of exceptions in the 51 Refugee Convention that are stated. You can find them in Article 33, the second clause, after the obligation is listed. And there a qualification to the obligation is provided to states where they may find grounds for danger to the security of their country. That qualification, it does not mention health, and it very specifically mentions that it would need to be an individual determination. It cannot be a blanket policy that applies to a group of individuals. The other stated exception in the international treaty is Article 9, which is very similar in nature and provides that a state can deviate from its responsibility, its legal obligation of non-refoulement in exceptional circumstances, but mostly refers to national security and refers to in the case of a particular person. So once again, an individualized determination would have to be made on the part of the state vis-a-vis an individual, not a blanket policy. And it should also be noted that there was a proposal made at the drafting of this critical international treaty. It was actually made by the United Kingdom to give states a blanket derogation power in times of national crisis. And it was turned down by the drafters, by the convening parties. And so there is no blanket derogation power vested in states under international law to apply a blanket policy that would nullify the access to asylum requirement. Now, I think it should be noted that there are certain counter arguments, of course, that have been advanced by the government. I think one I want to address, a possible argument would be, well, Haitians are possibly deemed migrants and not refugees, and therefore they're not owed that duty not to refoul them or return them to Haiti. Well, to that, I would argue that the TPS designation that was mentioned explicitly says that Haiti is grappling with a deteriorating political crisis, violence, and a staggering increase in human rights abuses. So on the one hand, our government has acknowledged that there are human rights abuses taking place. We cannot then deem Haitians only migrants. We have to accept that many will be in possession of valid claims for refugee status. Now, I want to talk about a bigger picture point about our treaty obligation, and that comes from Article 31 of the Vienna Convention, which says that treaties must be construed according not only to the ordinary meaning, but also in light of their object and purpose. Here again, the Refugee Convention's purpose is clear, that international protection is due when one's own government will not or cannot protect them. And so we have to understand, to interpret that if the Haitian government is not capable of protecting individuals right now, then our obligations under the Refugee Convention create, once again, an obligation to offer protection to them. I want to quickly make clear that the non-refoulement obligation also appears in other instruments to which we're a party: the Convention Against Torture, the ICCPR, and the American Convention on Human Rights. All contain similar, if not the identical, non-refoulement obligation. And I also want to make clear that the non-refoulement obligation is now widely understood to be customary international law. So going above and beyond our obligations according to the treaty, it's widely understood that all countries, whether signatories to the Refugee Convention or not, are bound by this obligation. And it is now risen to customary international law. Many argue it has risen to jus cogens peremptory norm status, and therefore cannot be derogated from in any situation or any circumstance. It's interesting to note that the US government has repeatedly interpreted its obligations restrictively and has argued that non-refoulement obligation does not apply as customary international law, and there has relied on a argument that it has not become widely, extensively, and virtually recognized across the world. And to that, I have a number of counter arguments there too. A number of states around the world who haven't even signed on to the Refugee Convention have acknowledged and recognized the non-refoulement obligation. And I can point to court judgments in foreign jurisdictions, including countries like Bangladesh, India, who have not signed on to the convention, who have recognized the non-refoulement principle. So I think we're coming down on the wrong side of this internationally. And I think that it's clear to a lot of voices. John mentioned Harold Coe. The UNHCR has come out and been more clear than it usually is in calling out governments on this, as far back as May, calling on the US to essentially lift Title 42 and resume allowing individuals to have access to the US asylum procedure. So I think it's pretty clear that this is not in conformity with our international legal obligations.
Thank you, Zaid. So you talked about some exceptions to that, to the refoulement laws and principle and explained them, and also determined that they don't apply. You also told us yourself in the beginning as a preface that you think we are not meeting our obligations under international law. So I'm wondering, what does it mean when a state like the US, or how are we viewed by international entities and other countries when we do not abide by refoulement or other principles that other countries either signed on to and or have determined is customary?
Yeah, thanks, Danny. I think that the implications are far-reaching. I think on the one hand, these kinds of actions send the wrong signal, and they absolutely contradict the U.S. government's position and what it calls for. On the one hand, I could say that 2 months ago, just 2 months ago, the beginning of August, the US State Department was calling on Pakistan to keep its borders open to Afghan refugees. I'd like us to just situate that and reflect on that at the beginning of August, we were asking a country like Pakistan, which is currently host to around 1.6 million registered refugees and likely hundreds of thousands of unregistered refugees already, to keep their borders open to Afghans who are fleeing the situation in Afghanistan, while at the same time we're not abiding by the fundamental core protection under international law. It sends the wrong signal and it undermines our legitimacy vis-a-vis other governments. And I think that this goes to some of the disappointment that's been voiced by others, that this administration had also made commitments to go back to being a leader on the global stage in terms of bringing the US back into a leadership role. And I think that these are actions and measures that absolutely contradict our role as a leader on the global stage. It also undermines some of the more positive elements of the administration's own agenda. This administration put out early on when it came in, put out a collaborative migration management strategy, which had a lot of really positive things in it, discussing, investing in building up the asylum capacity in the region, including in Mexico. I think if we're to expect the Mexican asylum system to develop, which is in the interest of Mexico, in the interest of the U.S., we're certainly not going to get that accomplished by carrying out actions such as this, whereby we actually expelled thousands of Haitians back to Mexico, in addition to those Haitians that we expelled directly to Haiti, placing a significant burden on Mexico and its asylum system at the moment. So we're not consistent with our own policies or priorities, and we're not, we're undermining our own legitimacy and the entire international refugee system.
Thank you, Zay. Wow, so we have just had 3 different perspectives, focusing on the border, and then zooming out a little bit, talking about Title 42, and then our obligations under international law, which Zaid described many reasons or bases for the conclusion that perhaps we are not meeting those obligations. Thank you all for each of your remarks. We do have time for some questions, and I think I can start us off with the first question, which is really for any of you. What can be said, or what do we know has happened to those families that were pictured, or to Haitians in general who have recently come and been subjected to treatment under, be it under Title 42 or any other iteration of what exists of our border protocols? Does anyone have information about any updates about those families?
I mean, I can just chime in to start with that there have been at least, my numbers are outdated because I didn't look at it since Monday, but there have been at least 65 deportation flights of Haitians back to Haiti, a country, as they pointed out, that we know is in no position to be able to receive them safely. And again, my numbers may be a little bit off, but let's say 5,000 individuals or so at minimum were on those deportation flights back to Haiti. And that leaves, another 9,000 or so people who were present at the Del Rio encampments, and a variety of things, other things happened to those individuals. Some were pressured to voluntarily retreat back into Mexico under threats that they may also be put on deportation flights. And then more interesting and proper looking things happened to some fraction of them as well, who were issued humanitarian exemptions to Title 42 and were allowed to be paroled into the United States while they pursue their asylum claims, which of course is how the system should work for anybody who is seeking protection. They should have the opportunity to seek protection in the United States. But interestingly, like, the US government doesn't want anybody to know about that piece because they think at this particular moment, like, the line they want to project is do not come. If you come, you will be expelled. Like, don't show up at the border. Miriam, or anything to add to what's happened?
I mean, I think so far, some of the things that I've seen, in addition to what you've already mentioned, that some people have been released and or bused to various states, mostly Florida, I think in Pennsylvania and New York. And so I think there's this issue of representation for a lot of people who are kind of lost. And that's what I've been seeing mostly.
So it sounds like there potentially might be some families who have since made it through into the United States and should be going through some type of immigration proceeding or deportation proceeding, and that there might be a need for representation for those families in the places that you mentioned and probably elsewhere.
Yeah. No, absolutely. And I think I just want to make clear that there are people who have been detained even before the news of, what has happened recently. So maybe a lot of the people who were recently released have been people who have been detained for a month or two. And so I think that's, they're all going to have different types of relief available to them based on their particular circumstances. But I just want to make it clear that I'm not sure if it's what group, I guess, has been released, but I do know that there have been buses of people transported, and a lot of the funds have gone to that.
Well, I can just an extension of that. I know that in New York, we have a robust pro bono practice, including at the City Bar and the City Bar Justice Center. And right now, there are asylum seekers from Haiti who might be in need of pro bono representation, or who might have representation but may still need help with interpretation for Haitian Creole language access. And then for any Haitian who has been in the United States since the most recent TPS designation, right? So that's the very end of July of this year. TPS, temporary protected status, might be an option for them. So there may be places that are seeking assistance with communicating with or assisting with applications for Haitian migrants who are eligible under the new protocols too. For more information about that, I'm sure that the City Bar Justice Center and the New York City Bar Association will have information and possibly a call for volunteers. But there are also 8 organizations that Miriam mentioned earlier on, and I'm sure John and Zaid have others in mind that could use assistance on this and other related subjects. So I want to now thank John, Miriam, Zaid, Sheila, the International Human Rights Committee, our Immigration and Nationality Law Committee, the New York City Bar Association, our gurus in the tech department. Thank you so much for all of your help in putting this together. It was a fantastic event, and Sheila Boston, I see you there. If you'd like to send us home, you get the last words. Thank you all.
Oh, wow, Danny, I hadn't really expected to do so. I just wanted to say thank you to our panelists and to all of our viewers. Let's go out there and do some good. Let's protect some folks. Have a great night, everybody.
Thank you. Good night, everyone.
Good night.